you can have a reasonable, legally defensible perception that the people coming into your home, even if they're actually police, were not police. Your perception, your reasonable perception was they were not police. And if that's the case, you're shooting at those actual police can be perfectly lawful. Be prepared. They're likely to shoot back. So I always encourage people, even when you're defending your home against intruders, it's prudent to do so from a position of good cover because you should expect incoming fire. In fact, I believe that at least one of these bad guys, in fact, did return fire at this point when the door just gets kicked open. Right here, kick, the door goes open, and I believe he fires right here, fires into the home. Right there. So he's shooting back until he gets overwhelming return fire and they all run away. So defending yourself from a position of cover is always a prudent thing to do. And the nice thing is it's your home, so you get to configure your home. You know, it's good cover from handgun rounds in particular is a shelf of books. So if you have a tall bookshelf, like you can get at IKEA, and just stack it with books, and you're shooting from behind it, and you're compelling them to shoot the length of the shelf of books, there's no handgun round going through that, folks. That's pretty good defensive cover. Just a tactical consideration there. Now, how can the apparent intruders being actual law enforcement officers, how can that influence your claim to legal justification in this kind of scenario? Well, Washington State does not do what I'm about to describe, but there are many states that have special provisions for the defense of highly defensible property that create a legal presumption that if you're dealing with a forcible and unlawful intruder into your home, that you had a reasonable perception of an imminent threat of unlawful deadly force. Folks, that gives you most of the elements you need to justify your use of deadly defensive force. There's only a maximum of 5 of these. And this legal presumption gives you 3. It gives you a reasonable perception of an imminent deadly force threat, which is proportionality. And avoidance is covered by the Castle Doctrine in every state. So that's 4 of the 5 elements are given to you to justify your use of deadly defensive force. By the way, if you'd like this little cheat sheet on the 5 elements of self-defense, you can get this at lawofselfdefense.com/elements. If you don't know those 5 elements, you can't possibly understand self-defense or defense of others law. Those are the building blocks of any claim of self-defense justification. So these legal presumptions in defense of highly defensible property, like your home, really give you 4 of the 5 elements you need for self-defense. The only one not explicitly given is that of innocence, that you were not the initial aggressor. But let's face it, that's pretty much baked into the cake if you're dealing with intruders coming into your home. So those statutes are pretty compelling. They do, however, routinely come with a number of conditions. And I'm just going to pick one here at random, one state's version of this kind of legal presumption from the state of North Carolina. And by the way, folks, these slides I'm about to share are from our North Carolina specific course. We have a state specific course for every state. You can get that for your state at lawofselfdefense.com/state, the little banner on the bottom of the screen here. And I believe we have a sale on those right now. So whatever state or states you're in, you can get your state-specific supplement course just like I'm sharing with you here. So this is section 9 of that course where we talk about defensive property. And of course, there are 2 buckets of property, 2 types of property, personal property and highly defensible property. I'm not going to go into a thorough breakdown of those, except to say personal property is really just things that could be picked up and carried away. And highly defensible property certainly includes your dwelling, which is what we're dealing with here. So we're looking at highly defensible property, which North Carolina defines as a home, motor vehicle, or workplace, which is a pretty broad definition. They don't include places of worship, and there are a number of states now trying to get places of worship added to this concept of a legal presumption in the context of highly defensible property. But certainly it includes a home. And how does this read? The lawful occupant of a home is presumed to have held a reasonable fear of imminent death or serious bodily harm when using defensive force that's intended or likely to cause death or serious bodily injury if both of the following apply. The person against whom the defensive force was used was in the process of unlawfully and forcefully entering, or had unlawfully forcibly entered a home, or had removed someone, or was attempting to remove someone, a kidnapping type of scenario. So, were these bad guys in the front porch? Were they in the process of unlawfully and forcefully entering the home? Obviously. But that's only one condition you need to qualify. The other condition is the person who uses defensive force knew or had reason to believe that an unlawful and forcible entry was occurring. Well, did they have reason to believe there was, they're not speculating here, right? They can hear the kicks on the door. They can see the door shaking. So both of these conditions would be satisfied, which would create this legal presumption that the homeowner had at least 4 of the 5 elements needed to justify the use of deadly defensive force. But it's not enough for these legal presumption statutes that you qualify for the conditions, for the check boxes that have to be checked. You also have to avoid the exclusions. This presumption does not apply in any of the following circumstances. These are the exclusions. The person against whom the defensive force is used has the right to be in or is a lawful resident of the home. So you don't get the benefit of this legal presumption if the person against whom you use the force was a co-dweller in the home. That doesn't mean you can't defend yourself against a co-dweller. You would just have to get these elements back on the table as part of your legal argument. It would no longer be legally presumed that these elements were satisfied. But the relevant, and there's a number of other exceptions, but the relevant exception for our purposes is that the person against whom the defensive force is used by the homeowner is a law enforcement officer who enters or attempts to enter the home in the lawful performance of his or her official duties. Now, imagine these 3 guys. Can you hear the train going by? Less than a year left in this office, folks. All right. So these 3 guys on the front porch. Let's pretend they were law enforcement officers serving a warrant in plain clothes, whatever. Let's pretend they were acting lawfully. Maybe they were sent to the wrong address, but they were cops acting in the performance of their official duties. Does that change what I said earlier, that the homeowner might have a reasonable perception that they're not cops and shoot them and have that shooting be lawful? No, it doesn't change that. That's just the core benefit, the core privilege of self-defense, that you're defending yourself against a reasonable perception. Your perception doesn't have to be perfect. It doesn't have to be accurate, but it has to be reasonably made. So you don't lose self-defense because it turns out that they were cops if you had a reasonable perception they were not cops. But what it does do, if they were cops, is that you lose the benefit of this legal presumption that these elements are satisfied, just like you lose it if the person you're defending yourself against is a co-dweller. So you don't lose self-defense, generally speaking, but you do lose the benefit of this legal presumption. If you knew or reasonably should have known that they were law enforcement officers coming in. And again, that's someone else's judgment call there. Let's see. By the way, when it comes time for others to evaluate whether your perception of these coming in, these actual cops, let's pretend we're talking actual cops, you're claiming you had a reasonable perception they were not cops, and that's why you shot at them. An important factor that the people deciding whether your judgment was reasonable, the police, the prosecutor, the judge, the jury, an important factor they'll consider in determining whether your claimed reasonable perception was, in their view, reasonable is, well, are you, for example, an actual criminal? Do you deal drugs out of the house? Because if you do deal drugs out of the house, you ought not be surprised when the cops show up and kick the door in. Right? It would be reasonable to expect the cops to come sooner or later. As opposed to if you're a non-criminal, you're just a law-abiding citizen in your home, maybe the cops go to the wrong address and they're kicking in your door, that lawful citizen would have a much more credible foundation on which to claim, I had no reason to believe the cops would be kicking in my door, so of course I assumed it was a home invasion. So Andrew's advice, don't be a criminal. Don't be a criminal.